anyone who's going to participate in the hearing today has to have their screens on, where their camera's on. And if they don't, I have no choice but to remove them from the hearing.
Matt, can you call the client and see if that's them?
Yes, I will.
Judge, I just called my client. I think he's trying to switch the camera back on. He's sitting there. He'll be on in a second.
Okay, I see your client. Your client is the he was the Max Pro, right?
Right, and he's restarting the Zoom because it wouldn't let him turn his camera on.
Okay, it's just someone on the screen now that just says iPhone. I'm just trying to figure out who that is.
And Your Honor, I just saw that you hopped on to YouTube Live. I will exit the meeting and just view from there.
Okay,
Thank you.
You're welcome. Good to see you.
Yes, ma'am. Thank you.
That's Williams lawyer. Oh, on the other side. Long.
Okay, Your Honor, that may not be our client.
Okay, so I'm just going to remove them from the hearing. They can watch on YouTube.
I don't have, they're not on anybody's witness or exhibit or witness list, Your Honor. They just wanted to, I guess, watch the sausage be made.
Okay, yeah, well, we're streaming live on YouTube in accordance with the Texas Open Courts Act, as well as the courtroom being open. So anyone on the 255th YouTube channel can watch it live. Okay. So all sides ready to proceed?
Yes, ma'am.
Okay, so you all are set for an hour total. The interveners, I split the time up with the hour.
An hour, Judge?
Yes, that's the setting. You all are set for an hour.
Okay, can you?
Counsel, I'm speaking. You all are set for an hour total, and all three sides has to have equal time. So everyone gets 20 minutes aside. The only issue that's before the court is what was spoken about with the Court of Appeals, and that is the property division. All right. So we're on the record in cause number DF2004783. Counsels, will you please announce for the record?
Bob Emerson, representing petitioner Quifam, who is also present.
Thank you.
Good morning, Your Honor. Stephen Davis, representing the interveners, Ted and Ann Casales.
Thank you.
Cynthia Willen Allen, representing Train Lee. She's the ex-wife or ex-spouse.
Okay, thank you. All right, so you're set at 20 minutes aside. This will include any opening and closing, should you choose to give, as well as examination. And I believe, Attorney Emerson, you're the movant. Is that correct?
Oh, we're petitioners. Yes, ma'am.
Okay. All right. You may make an opening statement if you choose to make one.
Thank you. May it please the court, just very briefly. And I apologize if I start talking too fast, given our short time. Please, court reporter, yell at me. As a summary of requested relief, we've listed it as Exhibit 1, but it's there as a courtesy to the court. It lists everything we're asking for. Basically, our perception of this case is that everything has already been determined, with the exception of the property division. And the property division is limited to the confines of the property that has already been characterized in the final decree of divorce. Pursuant to that, we have provided in our summary of requested relief two separate proposed property divisions. One is based on Mr. Pham's number, one is based on Ms. Lay's numbers. And frankly, we are going to be asking that one or the other be entered. We're kind of okay with either of them. It's, just what the court finds to be, a just and right division. With regard to the contested issue, you probably reviewed a trial brief filed by interveners. It has to do with the Lamborghini. I just want to draw you specifically to the language of the final decree of divorce. The Lamborghini, and that's all it's ever called, the Lamborghini is not characterized as community property in the final decree of divorce. It's in an other provision, which is categorically the same as the spousal maintenance provisions. And we all know spousal maintenance is not a community property. And as such, the discussion of of the Lamborghini will be objecting to relevance heavily because it has not been characterized as community property. And we aren't here on further characterization. You're going to see the same thing in a bunch of Ms. Lay's exhibits. The other thing you're going to see procedurally is Ms. Lay failed to turn over any documents with updated values by the 30-day deadline as mandated in your pretrial order. They've submitted some extra exhibits as of last night. None of those were turned over either. So you're going to see a bunch of objections coming from our side, and we just ask for your patience. But overall, we're asking that the court divide only the property that's listed in the decree, and only divide property. And that does not include the Lamborghini that has been pleaded and briefed by interveners. Pass.
Thank you.
That's my opening. Thank you.
Thank you. Attorney Allen?
Yes, Your Honor, I'll waive opening.
Okay. Attorney Davis?
Yes, Your Honor, very briefly. The decree states, number one, that the Lamborghini was purchased with community assets. The Court of Appeals affirmed that decision. I'm here for one reason only, and that is we have a judgment against Quifam, as you can see from our trial briefing. I have two exhibits, a copy of the original lawsuit, which is a certified copy and therefore self-authenticating and admissible, and a certified copy of the judgment showing that the judgment is for torts, meaning that the community estate of both parties is subject to satisfaction of the judgment. As you know, the 95th Court of Appeals asked me to come intervene in this case because I was trying to collect up there. The characterization of the Lamborghini is not before this court. And if you look at the Court of Appeals mandate, it's pretty clear about that. If the plaintiff wanted to argue about how the Lamborghini was treated, they needed to file an appeal to the Supreme Court based on the Court of Appeals ruling. The Court of Appeals opinion explicitly states that the husband did not present any documentary evidence to support his claim that he did not purchase or own the Lamborghini. And if you go into the bottom of the opinion, the only thing that was reversed is spousal support, which I don't care about, and an issue regarding a GMC Sierra, which I don't care about. The main thing I would like to tell the court is I have a judgment for, as of today, $851,000 for fraud that there has been no attempt to satisfy or any attempt made to resolve that. And I believe that the interveners pursuant to the property code are entitled to all non-exempt assets in the community estate. And that includes the Lamborghini. And so we would ask that any non-exempt assets, and under the property code, Your Honor, because these individuals are getting divorced, they're each entitled to $50,000 in exempt assets. There is a Ferrari listed in Mr. Pham's inventory. There is the Lamborghini, and both of those items should be turned over to the interveners to sell to satisfy the judgment or to offset the judgment, because even a Lamborghini and a Ferrari will not sell for enough money to satisfy a judgment that is $851,000. Thank you.
Thank you. All right. Attorney Emerson, you may call your first witness. Oh, you're on mute, Attorney Emerson.
Sorry, I'd like to call Petitioner Quifam.
Okay. Would all those who intend to testify, please raise your right hand. All right. Raise your right hand. Oh, thank you. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, sir. Yes.
Ma'am, I didn't get your answer.
Yes.
Thank you. Attorney Emerson, you may proceed.
Thank you so much. Please state your full name for the court.
Kui Pham.
Okay. And you were the petitioner in this divorce matter, correct?
Yes.
Judge, we'd like to ask that you take judicial notice of the final decree of divorce entered by this court in October 19th, 2021.
The court takes judicial notice of the divorce decree entered on October 19, 2021.
Mr. Pham, I'd like to draw your attention to our Exhibit 1. Is this a summary of the relief you were requesting of the court today, provided as an aid to the court?
Correct. Yes.
And it has two separate proposed property divisions attached to it.
Correct.
And we've also listed those as Exhibits 23 and 24, correct?
Correct.
I'd like to offer husband's Exhibit 1.
Okay, any objection?
I object, Your Honor. It's a summary that he hasn't testified about, and that's not evidence.
Okay, any other objections? Attorney Allen?
No,
Okay, overrule. Husband's Exhibit 1 is admitted.
Thank you, Judge. Of these two proposals, does one of them contain the numbers you provided on a sworn inventory and appraisement?
Yes, sir.
And if you look at Exhibit 20, is that a sworn inventory and appraisement that you filed with this court?
Yes, sir.
That's the spreadsheet that was attached to your sworn inventory and appraisement?
Yes, sir.
If I were to go line by line down each and every one of these, is this a true and accurate listing of the pieces of community property that are listed in the final decree of divorce and your valuations of them?
Yes, sir.
I'd like to offer husband's Exhibit 20.
Any objection?
objection, Your Honor, to his number 20. In the event that he has listed liabilities, he's not put a value to it, either to husband or wife. So it's incomplete. It's confusing.
Okay, any other objections?
No, Your Honor.
Okay, overruled. Husband's Exhibit 20 is admitted.
Mr. Pham, going through this, the property values based on the columns after the value division are for who's in which person's possession they are in, correct?
Correct, sir.
And if we look at your ex-wife having the house, the timeshare, her retirement, the Ferrari, and all the cash values of life insurance and a secondary business, that gives her 177% of the estate.
Correct, sir.
Okay, and the reason the liabilities listed at the top, those were found in the decree, correct?
Correct, sir.
At the time of final trial, was it your understanding that those had already been paid in full?
Yes.
And those have been paid?
Objection, Your Honor, his witness. Objection, Your Honor, he's leading and testifying for his witness.
Sustained, don't lead.
Thank you. Had those, at the time of final trial, did those credit card obligations, were they still owed?
No, sir.
Okay. And your valuation for the residence is 1.12 million?
Correct, sir.
Okay. Is your number for the Casalis's judgment found on this spreadsheet?
Correct.
And you got that off of the lot? Where did you get that?
Off the case.
The lawsuit they filed to collect?
Yes, sir.
Okay. Now, very briefly, you put on here that the cash value of the insurance policy in your name is in your wife's possession. Why is that?
She's the one that set up all the account for me.
Is it your understanding that she's already cashed that out?
Yes.
Okay. But do you know anything about where those funds have gone?
No, sir.
Okay. I would like to show you what has been marked as Husband's Exhibit 18. This is the proposed property division based on that same inventory that goes with Exhibit 24, which was attached to the summary of requested relief, correct?
Correct.
Okay, I'd like to offer husband's Exhibit 18 as a summary of his request for property division.
All right, any objection?
No objection at this time, Your Honor.
Okay,
No, Your Honor.
all right. Husband's Exhibit 18 is admitted.
And now, Mr. Pham, I'd like to draw your attention to husband's Exhibit 19. Is this the same thing where it's a summary of your proposed property division using Miss Lay's values?
Correct, sir.
I'd like to offer husband's Exhibit 19 as a summary of Exhibit 23, which is attached to the summary of requested relief.
Okay, any objection?
Judge Elbert, I don't object to this, but I do object to misstatements of facts in it. So I do that on cross-examination.
Okay,
I'm
Attorney,
not trying to work with numbers.
Your Honor, I object to the fact that it's a summary and it's not a summary of his testimony. Apparently, it's a summary of the wife's information, and I don't think that's proper. I think it's hearsay.
okay. Objections overruled. Exhibit 23 is admitted as a summary.
Thank you. Mr. Pham, have you ever purchased a Lamborghini?
No, sir.
Have you ever owned one?
No, sir.
Objection to this line of person has not been relevant, Your Honor.
I
It's
second
already
that
been
objection, Your
determined.
Honor.
Hold on one second. Attorney Allen, I didn't get your full objection.
I object to this testimony as being not relevant. It's already been determined by the Court of Appeals that it's community property.
And
Attorney Davis?
I further object on relevance and the fact that it's the law of the case regarding the treatment of the Lamborghini, Your Honor. It is not before the court.
may I respond, Judge?
Go ahead.
Very briefly, so if the court does take the posture that the section for other debt is a categorization of community property, the court is limited by the language of the decree, which says the Lamborghini. It never describes whose possession it is in. And so I'm just doing this to elucidate whether or not the Lamborghini everyone has their laser focus on here is the Lamborghini referred to in the decree.
Overrule you. I'll allow it.
Has your name ever been on the title of a Lamborghini, sir?
No, sir.
Are you aware of a Lamborghini owned by your ex-wife while you were married?
Yes.
I'd like to show you what has been marked as Exhibit 14. Is this a true and accurate copy of the Department of Motor Vehicles public information request of the title history from a Lamborghini purchased by your now current wife while you were still dating her?
Correct.
Okay, and we have the judge. I'd like to offer husband's Exhibit 14. The business records affidavit has been on file with the court
Objection, Your Honor.
for 14 days, and documents were provided 30 days out.
Okay. Attorney Allen, what's your objection?
He said that it's been on record for 14 days.
He said it.
No, it's two different things, Judge. Number 14. The business record affidavit is only to 6 pages, 320 through 325. And this is talking about the Department of Motor Vehicles. So I object that he wants to introduce 14, but that's not what his business record affidavit is.
May I respond, Judge?
Not entirely. So it's extraneous documents attached. That's not in the affidavit.
May I respond, Judge?
Well,
And I object to pieces.
before you respond, Attorney Davis, do you have an objection?
Yes, Your Honor, just to the point that it is a Texas motor vehicle record. It is not a business record of qui fam. So therefore, the fact that it is been on file for 14 days doesn't make it his business record. And I don't think that the cover page provided by the Texas Department of Motor Vehicles qualifies it as a business record. You can get certified copies of documents from the Texas Department of Motor Vehicles, and that's not what these are by my review.
May I respond, Judge?
Yes.
These are certified copies from the Texas Department of Motor Vehicle. I did belt and suspenders here. This technically falls under the exception of hearsay 803 subsection 6, which is a regularly conducted activity. Number one, it also falls under 803.8, which is a public record, or 803.10, which is the absence of a public record. In other words, I'm showing that the Miss Lay and Mr. Pham never owned this. Additionally, it's 803.14, document affecting interest in property, and it's a business record of the Department of Motor Vehicles. So essentially, I followed literally all of the prongs of the hearsay exception in the Texas Rules of Evidence.
Objections overruled. Exhibit 14, counsel,
Yes, yes, ma'am.
submitted.
Okay, and sir, this is the printout from the Department of Motor Vehicles for all owners of the Lamborghini that is listed in the intervener's brief and request of this court, correct?
Objection, Your Honor. He can't testify about somebody else's documents. The documents either speak for themselves or they don't.
Response?
He's a party to this suit. He's reviewed their pleading against him. The idea that he's not aware of the pleading against him is, I think, frankly, a little inflammatory, but also unfounded, and that isn't a real objection.
Okay, and the court's position is that his testimony regarding an interest in property would fall under 804.13. So the objection is overruled. You may continue.
So, Mr. Pham, this is the same Lamborghini that is listed in the intervener's pleadings, correct?
Correct.
And nowhere in any of these documents does it list you or Miss Lay, correct?
Correct.
Are you aware of the judgment against you agreed to against the interveners?
Yes.
What year did they pay you for the work on their residence?
I think it was 2009, sir.
Okay, and what did you do with the funds you earned in doing the work or attempted work on their residence?
Pay for mortgage and everyday expense and living and funds for kids' school, kids' education.
Is it your goal to use the assets awarded to you to pay off the interveners in full?
Objection, Your Honor. It assumes facts not in evidence. And additionally, we had previously objected before that it's not relevant, and I'm now saying that it's not relevant what he did with the money. It's not relevant to this case in the division of community, the community estate.
I believe the question was, what did you do with the funds you earned during the work or attempted work on their residence? Was that the question?
Yes, ma'am.
Okay.
It's not relevant, Judge, to the community division. This was not a part of the record before. And I believe the Court of Appeals says that you just have to redivide the community estate, not for any judgments.
Counsel, what's the relevance?
So if they're taking the position that this debt should be put in the bottom line of the community, I'll move on. I just want to be sure, similar to what Mr. Davis argued, that this debt obligation is tacked on to the entire state, not taken off the top and put in Mr. Pham's column. And if it sounds like Ms. Allen is in agreement to that, so I'm happy to move on.
Okay, you may ask your next question.
Thank you.
I don't know what he's claiming I'm in agreement, but I just objected to the relevance. So I'm not agreeing with whatever he's saying.
Mr. Pham, are you asking the court to divide the property in a manner that will permit you to satisfy the debt owed to the interveners as a result of the judgment against you?
Objection, leading his witness.
Overruled.
Objection, he's leading and suggesting.
And I ruled. Overruled.
He's testifying.
Overruled.
I didn't hear you. I didn't hear you. That's all I said. I didn't hear you.
Okay, counsel, we've already established you didn't hear me. No more outbursts. Go ahead, counsel.
Pass witness.
Okay. Attorney Allen?
Yes. Now, let me ask you something, sir. Did you go with her to get that Lamborghini and did you pick it?
Objection, relevance.
Counsel, what's the relevance?
That he picked it and it's his. He bought it. That's what I'm trying to establish. He's trying to establish that it wasn't his. I'm trying to establish that it was his. So I'm asking it, did he pick it? And did he write the check for $200,000? That's just a yes or no.
Okay, so ask one question. Go ahead.
I didn't hear him answer.
You need to repeat
Can you
the
instruct him to
question.
answer, Your Honor?
I can instruct him to answer when you repeat the question.
Okay, maybe we're having a freeze because I can't hear you when you said that, Judge. On our exhibit number 12.2, sir. Can you pull it up, Erica? Did you write the check for $200,000 in buying this Lamborghini? Did you write that check, sir?
Objection. Testifying to a document, not in evidence.
Sustain.
I'm asking my office. I don't have a checkup. I'm asking him to, Erica, can you pull up Respondent's Exhibit 12.2?
And you all can share the screen when you need to.
Erica, 12.3 and 12.2. Quickly, please. Judge, is Erica on in my office? Okay. Sir, is this your writing?
May I answer, Your Honor?
Yes, you can answer that.
Not my handwriting, ma'am.
Judge, I'm just not clear. Is this being offered into evidence?
Nothing further.
Counsel, were you offering this into evidence?
No, he said he didn't, it wasn't here. I
Okay,
passed the witness. I don't want any more on my time.
okay. Attorney Davis?
Yes, Your Honor. Mr. Pham, I'm going to show you what has been marked as Plaintiff's Exhibit 15. Or sorry, Husband's Exhibit 15. This is your exhibit. Too many PDFs open. Can you see that?
Let me pull it up. Yes.
And it was your intention to present this as evidence to the court today?
Yes.
Your Honor, I would move to offer Husband's Exhibit 15 into evidence.
Okay, any objections?
No objection whatsoever.
No objection?
Okay,
I just one thing for the court reporter, and I apologize, this is my fault. With the exception of the first page, I messed up and did not cross out prior exhibit stamps. I'm sorry. It says defendants 4 through 6. Those are inaccurate. I apologize.
okay,
We're talking about right here, this
Yes, sir.
guy? Okay.
Attorney Emerson, would you please send your exhibits to the court reporter?
I will resend them. Yes, ma'am.
Okay. And Attorney Davis, does the court reporter have this? You have this?
Yes.
Yes, Your Honor, this is technically the husband's exhibit. It's not mine.
Oh, okay.
So,
Okay, husband's exhibit 15 is admitted.
Mr. Pham, can you see that this says the buyer is Trang Do right here?
Yes.
And the resident's phone number, the business phone number, that's your phone number, correct?
Correct.
And email quifam234@gmail.com. That's your email, correct?
Correct.
Your Honor, as a belt and suspenders, I'd move to offer interveners Exhibit A and interveners Exhibit B. They're certified copies of court pleadings.
No objection.
Attorney Allen?
No objection?
Okay. Interveners exhibits A and B are admitted.
Looking back at husband's Exhibit 4 that you were just discussing, this, as you can see from the bottom title, has Trang Do listed as the owner of this property, correct?
Correct.
As the owner of the Lamborghini? Does she own more than one Lamborghini?
No.
And if we look down here, I'm not going to read the whole thing because the poor court reporter would hate me, but page 2 has a vehicle identification number. Oh, can't highlight it. Right here that starts either with a 2 or a Z, 2HWUR. Do you see that?
Yeah. Where you said that? Where is it at?
Right. Can you see my cursor by any chance? Right there.
Mhm.
Right there. Man, I'm terrible at this. Do I have a laser pointer in here somewhere? Do you see? It's ZHWUR12D6GLA04253. Do you see that on your screen?
Yes, yes, I can.
So if Miss Doe only owns one Lamborghini, can we agree that this is the Lamborghini we're talking about? And that's the
Correct.
number for it?
Correct.
Pass the witness, Your Honor.
Okay. Attorney Emerson?
Can I get a time check?
Sure, I'll give everyone one. Attorney Emerson, you have 8 minutes and 19 seconds. Attorney Allen has 14 minutes and 37 seconds. Attorney Davis, you have 13 minutes and 7 seconds.
Thank you. Very briefly, Judge. Mr. Pham, as they pointed out, your name and phone, or your email address and phone number are on that purchase sheet for the Lamborghini, correct?
Correct.
Why?
I would just assist her in the purchasing.
Is English your Miss Doe's first language?
No, sir.
Would you characterize, how would you characterize her English skills, particularly in navigating the purchase of a $500,000 automobile?
Objection,
Very
relevant.
poor.
Hold on 1 second. I didn't get your objection, Attorney Allen.
Objection, relevance.
Okay.
Assumes facts not in evidence.
I'm going to further object, Your Honor, to speculation and hearsay. If they wanted Miss Doe to come testify about her ability to purchase this car, she could be here testifying.
May I respond?
Yes. What's the relevance?
It's relevant because it seems as though they're trying to say his name and his email address and phone number being on there are problematic, and I'm eliciting an explanation for why. With regard to hearsay, there's no out-of-court statement we're trying to offer for the truth of the matter asserted.
Okay, overruled. I'll allow it.
Thank you.
May I respond, Judge?
No, I've ruled. You may continue, counsel.
And sir, I didn't hear your answer. You said her English skills with the ability to conduct a high-level transaction like this are what? How would you describe them?
She's her English is very poor, sir.
Okay, pass witness.
Thank you. Attorney Allen?
Nothing further.
Attorney Davis?
No questions, Your Honor.
All right. Attorney Emerson, you can call your next witness.
I would like to call Ms. Trang Lei, respondent.
Her name is Lee, L-E.
Attorney Emerson, you may proceed.
Please state your full name for the court.
Trang Lee.
And do you own a Lamborghini?
No.
Have you ever purchased one?
No.
I think I can hear it's just coming through a different person. Is that what's going on?
I can't hear anything.
Okay.
I can't hear
Did you?
anything that you're asking.
Hold on 1 second. Hold on 1 second. Attorney Allen, is your client in your office?
She is, we only have one mic on.
Okay, she needs to be in her own.
Can you hear her?
No, like maybe because you all are in the same space, we can't hear her at all. So is there a separate office that she could sit in?
Is it
Because-
mine that's freezing?
No, if she can't hear us, that means somebody is relaying the message to her. And that's not proper
Close.
to be able to hear. Attorney Allen's paralegal, would you disconnect her and restart her Zoom? Is Attorney Allen coming in on a cell phone? Attorney Allen's paralegal.
I'm sorry, I was helping her log back on. She's logging back on.
Okay, is she logged
Attorney Allen.
on Samsung or is it under her name?
It's on her cell phone, so I'm not sure what comes up.
Okay, thank you.
You're welcome.
Okay, can you hear me, Judge?
Yes, I can.
Okay, I'm sorry about that confusion. I couldn't hear anything and you was frozen. I'm not trying to be disrespectful, Judge. I'm just trying to hear.
No, I wasn't frozen. Your computer was messing up.
That's what I'm saying. You were frozen on my computer.
Oh, okay. Can your client hear? That's what's most important because she's on the witness stand.
She's in a different room, so you ought to be able to hear.
Okay. Ma'am, would you please unmute? I'm sending you a prompt.
Can you hear me?
Yes, I can. And Attorney Emerson, I paused your time during that.
Cool. Thank you. Thank you. Do I need to start all over?
The last question that I have here is, you asked her, has she ever purchased a Lamborghini? She said no.
And you aren't aware of any Lamborghini that Mr. Pham purchased during the marriage, correct?
I am aware.
Is that your allegations about that? Is that the one that we just entered exhibits on?
Yes.
Okay. And you were married to Mr. Pham at the time the judgment was entered into between Mr. Pham and the Casaleses?
Yes.
Okay. And I'd like to show you, Judge, if I may screen share, what has been marked as husband's exhibit 12. Do you recognize that?
I can barely see it. Oh, is that an email?
Yes.
Yes.
And this is an email you sent Mr. Pham, correct?
Yes.
Okay. And Judge, I would like to offer husband's exhibit 12.
Objection to relevance, Your Honor. Objection to settlement negotiations.
Okay. Attorney Davis, any objection?
No, Your Honor.
Okay. Counsel, is this a settlement negotiation?
No,
It's a settlement offering.
No, Judge.
That will be the last time. Hold on one second, Attorney Emerson. That is very unprofessional. That will be the last time that you make an outburst in this court. Go ahead, Attorney Emerson.
No, Judge. Way back when there was some payment schedules that pertain to child support and stuff like that they were sending back and forth, but they aren't attached. And what you'll notice what they're agreeing to is that the judge will decide. So I wouldn't call that a settlement negotiation.
Okay.
If you
Overruled.
may I respond, Judge?
Oh, you may not. I just ruled.
Well, you didn't let me give my objection.
You gave your objection, counsel. I asked him for a response.
I said it was settlement negotiation. I want you to read all three pieces because they talking about settlement back and forth.
If you make an objection, I can't read it. That's what the reason I asked counsel. Go ahead, Attorney Emerson. Husband's Exhibit 12 is admitted.
Miss Lay, this is your statement to Mr. Pham here that I've highlighted. Is that correct?
Yes.
Okay.
Objection, relevance.
She answered the question.
I'm trying to stop share, but it won't let me,
It
guys.
stopped.
I did? Okay, cool. I guess my screen is just stopping. Okay, so you guys can see all of us, it's not up?
Yes, correct.
Okay, sorry. Okay, and you sent this email immediately after the Court of Appeals decision was received, correct?
What is the date on it?
June 5th, 2023.
When was the appeal?
Ma'am, how much is presently in your checking account?
I don't know.
Okay. Is the Ferrari F430 in your possession presently?
No,
Did you sell it?
it doesn't belong to me. It belongs to my brother.
So when did you sell that to him?
He's always had possession of it.
Okay, when did it get titled in his name?
It's always been titled in his name.
Okay. And what is his name?
Ngauk Lee.
Okay. And is a 2017 Honda Accord in your possession?
Yes,
Okay. And your retirement account has about $160,000 in it. Is that correct?
$158,547.
All right. Pass witness.
Okay. Attorney Allen.
I'll pass the witness at this time.
All right. Attorney Davis.
Yes, Miss Lee. Are you sure you didn't transfer the Ferrari into your brother's name after this divorce case was filed?
No, sir.
Did your brother purchase the Ferrari?
I don't have the details how it was purchased. I wasn't a party.
But it was part of the original decree to be placed or divided to your community estate, correct?
Yes,
So you would have had to have given it to your brother, correct?
you have to ask Mr. Pham.
Did Mr. Pham buy the Ferrari?
I'm sorry?
Did Mr. Pham buy the Ferrari?
Well, they are in it together. I just know that it's in my brother's name and my brother has money in it.
You say your brother has money in it. What does that mean?
His investment with Mr. Pham.
Does your brother drive the Ferrari?
I don't know.
Did you have to sign any documents to transfer the Ferrari to your brother?
No.
But it was given to you as part of the divorce decree.
Yes.
No further questions, Your Honor.
Okay. Anything further from this witness?
Subject to recall, no, ma'am.
Okay, thank you. Attorney Emerson, you may call your next witness.
Subject to recall, no further witnesses.
Okay. So you rest?
Yes, ma'am.
Okay. Attorney Allen?
Thank you, Your Honor. I first like for the court to look at my exhibits, respondents exhibit list and my exhibits. Ma'am, and I think that the court reporter has them. Can we verify that, Judge?
She has them.
Okay. So, Ms. Lee, can you tell us, ma'am, what you want this court to do today?
Award me my requested relief.
Okay, and what specifically is your requested relief? On the division of property, ma'am. Is that your exhibit number 5?
Yes, it is exhibit number 5.
Erica, can you bring exhibit number 5 up, please? Now, the house that was awarded to you previously is the house at Mountain Lakes in Cedar Hill. Is that correct?
That is correct. Yes.
And on your exhibit number 6, you have the decaf value listed at 830. Is that correct?
Yes.
Okay. So on number 1, he put the value at 1.12. And what is the current value as of November of 2023 at the 2242 Mountain Lakes Drive?
830,000.
Objection, hearsay.
It's DCAD.
Judge, a person can testify as to what their opinion is, but I'm going to put it in an exhibit. If you can pull up exhibit number 6, please.
Okay, is she giving an opinion or is she giving what she saw of DCAD?
She's given an opinion, and now we're going to prove it. On number 6, exhibit number 6.
Okay, overrule.
Erica, can you pull up number 6, please? And did you get that from the decap, ma'am?
Yes.
For 2023 certified values.
Yes.
And it was told in this divorce action that Mr. Pham had bought his girlfriend and built her house. Is that correct?
Objection leading, objection relevance.
What did he build for her?
Hold on, Attorney Allen. Sustain.
What did he build for her?
Objection relevance.
What is the relevance?
Judge, because he said throughout the transcript that he wanted a divorce and that he built his house and he built the house and didn't charge her anything, nothing. A $1.4 million house.
Is the transcript an exhibit that the court should be looking at right now?
Yes, we have it on our exhibit list. So let me go ahead and ask the court to admit the transcript, Judge, which is our number 3. Can you pull it up, the transcript?
Okay.
If the court can take judicial notice and we can send you the transcript, but we all got the transcript, Judge.
The court cannot take judicial notice of the transcript, but if you wish to admit it as an exhibit, the court can entertain that.
I would like to admit number 3 as an exhibit, the transcript of the final trial.
Okay, any objection?
No, Judge.
No, Your Honor.
Okay, Respondent's exhibit 3 is admitted.
Can we go to exhibit 4.1, Erica? A portion of the transcript, ma'am, can you see respondents 4.1 on page 106?
Yes.
Line 8. Question. I want to read the question. I want you to read the answer.
Yes.
Okay. Now, with regards to the cars and vehicles that you bought up, did you state that you told your wife she could have those things? Is that correct? His answer.
Objection, Judge. She's testifying. The document speaks for itself.
No, Judge, I have the right to do what I want on my time. Is that correct?
No, you have the right to follow the rules. You can ask your client to read from the document and you can question her on it.
Ma'am, would you look at the document 4.1 on line 17? What is the question? What is the question, ma'am?
Okay, was it your intention to tell her that you did not have an interest in any of those things?
Answer. What did he say?
I'm not interested in any of those.
What is the next question?
Okay, so are you telling the court that all you want is a divorce?
Answer.
Yes, definitely.
Okay, let's turn to 4.2.
Yes.
4.2, page 309, line 18.
Your
The
Honor,
petition.
Your Honor, I just want a divorce final. I want to give her everything so she can sell what she needs to do so I can move on, Your Honor. That's why I release everything to her. I just want to move on with my life.
Thank you. Let's go back to exhibit number 5, please. Erica. So, ma'am, you are wanting the only car that you have, which is the Honda Accord. Is that correct?
Yes,
All right. And did you put that in your column then?
yes.
Now, let's talk real quickly about the GMC Sierra. And that is,
Objection, Judge. Relevance. That is the piece of property that the appeal was successful on, which is why we're here today. The court found that that was not part of the community estate.
the court found also, Judge, that the Lamborghini was a part of the estate. And so I want to show and correct the community estate on this GMC, where they said I was confused.
And
May I
Judge,
proceed?
characterization has already been decided. That's not it. It's well past plenary power for that.
Just the Lamborghini has already been decided, way past preliminary power for that. So I'm looking to just show you where we got the 23,000 for it. And this isn't coming on my time?
Yeah, it's going on both of your times. So
I just need a ruling. Judge.
I gave a ruling. I said overrule, you may continue.
Okay, thank you. Let's go to exhibit number 8, testimony number 8, page 23 and 24.
Yes.
Okay, what did he say that he did with the truck, the F-350?
Objection, relevance.
What's the relevance?
Just as a part of the community estate. It's the truck he was driving then, when we did this divorce decree.
And may I respond?
Yes.
It is not in the final decree of divorce, and there's not a catch-all for automobiles.
Judge, it's in the final decree of divorce. It is in the final decree of divorce, and so is a Jeep.
Okay, counsel, did you want to pull up the decree and show me about the vehicle being mentioned in the final decree?
Absolutely. I don't know if it's, tell me if you guys.
No, not you, Attorney Emerson, Attorney Allen.
Sorry. Oh, no, ma'am. No, ma'am, I do not.
Okay.
Let's go back to respondents number 5, please. Ma'am, where did you get the value of $102,000 for the F-150? F-350, I'm sorry.
Objection, relevance.
Counsel, are you just talking about characterization again?
Yes.
Okay, overrule.
Ms. Lee, did you hear me?
Please ask me the question again.
Where did you get the value of $102,000 for the 2022 F-350?
That was the Cali Blue Book at the time.
Objection, relevance, Judge. They were divorced in 2022. I mean, 2021.
Counsel, what's the relevance?
Ma'am, he bought a truck before they got divorced, and this is the truck he was driving. So even if they got divorced, it was September. He had already bought him a brand new 2022. That's why the GMC was traded in for the F-350.
It was purchased after the marriage, right?
During the marriage.
Judge, I don't believe he owns or ever owned a 2022 Ford F-350, but. So,
Judge, did you rule on it?
Overrule, you may continue.
Okay, so ma'am, let's talk about how then are you asking the court to look at the GMC's value? Explain to the court why you want her to give you the 23,287.
The GMC was part of the community property. He traded in the GMC, which he wasn't allowed to, for a new truck. And the trade-in value is the equity amount is $23,287.63.
And where do you get that number from?
Exhibit 7.
May you bring up Exhibit 7, please? Erica, while you're doing that, can you bring up Exhibit 7? Can you bring it up wider? Can you see that, Judge? Bring it up wider.
It's small.
And you see that number, it says equity amount, and what amount is that?
$23,287.63.
Judge, may I take this witness on voir dire?
Move to admit respondents number 7.
Objection. Objection, hearsay. May I take this witness on voir dire?
Yes.
Ma'am, it's your position that this truck was traded in for a 2022, correct?
This truck was traded in for an F-350.
A 2022 F-350 is what you testified to not a minute ago?
I'm testifying that it was traded in for a new truck, F-350.
And do you see the date on this? What is the date for the dealer's and buyer's signature?
September 17, 2020.
Are you asking this court to believe that the 2022 models were already out?
Your Honor, I want to object to this line of voir dire. This is cross-examination and not personal knowledge.
Overrule. Ma'am, you may answer the question.
Please ask the question again.
Are you asking the court to believe that a 2022 model was out in September of 2020?
I'm testifying that the GMC truck was property and it was traded in for an F-350.
Objection, non-responsive.
Hold on, one question. This is the question, ma'am. Do you want the court to believe that a 2022 model was out in September of 2020? Yes or no?
I don't know.
May I qualify? Is that the right number? Was it a 2022 or was it a different model?
I know that it's a Ford F-350.
Okay, okay. But that's where you got the number amount. Is that correct? Now let's move forward.
Objection, hearsay, if she's getting it off this sheet.
Judge, I moved to admit we're from the 7. It's a 2018, Judge. I'm sorry.
Well, that conflicts with her testimony.
No, she never said that. Well, I'll move on, Judge.
Okay.
Judge, I do want to admit respondents number 7.
Objection, hearsay.
Sustain.
Do you recognize your husband's signature on the bottom of this? As buyer's signature?
Yes.
Is that his signature?
Yes.
How do you recognize it?
I've seen it.
How many times?
Many times.
Move to admit number 7.
Objection, hearsay.
Sustain.
Okay. Ma'am, let's go to your exhibit number 10. What is it?
Title application for a Mastercraft.
And is that the boat that you were awarded?
Yes.
Whose name is on the boat?
Long Nguyen.
And who is that?
His business
Yes.
partner.
Objection, relevance.
Counsel, what's the relevance?
This is a part of all this is a part of the community estate at the time of the divorce. This boat was awarded to her. It's titled to somebody else. It does not belong to her. She does not get the boat because it belongs to Long Nguyen.
Overrule, I'll allow it. Ma'am, you may answer the question.
It belongs to Long Nguyen.
Now, what was the what did your husband used to do when he bought vehicles and things of that sort? What would he do?
Objection, relevance.
Well, we're trying to explain these titles. I think it would help the judge. When he want to buy a vehicle, what would he do? Would he put it in his name?
Objection, leading. Objection, relevance.
Counsel, what's the relevant? Well, sustain as to leading, but what's the relevance?
Judge, you'll find that these titles are titles to other people. So the relevance is what his mantra was. What he always did was bought things and then put it in other person's name. I'm going to ask I want to ask my client, how many times did he do that and on what items? This would help the court to know what's community property and what's not.
And Judge, she just hit the nail on the head. We aren't here determining what is community property and what is not. The plenary power is long since passed for any of that. We are not.
Okay.
Continue, Attorney Emerson.
We are not characterizing. All that we're doing is valuing and asking you to divide it as you see fit, just and right. And as far as I could tell, this has nothing to do with valuations.
Sustain as to relevance.
Then we just
you have 2 minutes and 2 seconds. Attorney Emerson, you have 2 minutes. Intervener has 11 minutes and 5 seconds.
Ma'am, how much you have in your retirement?
$158,547.
And how much does he have in his?
$161,916.
Did you put in his column what you think that would be a fair and just amount for both you and he?
Yes.
Okay. Now you have life insurance that he claims is $25,000. How much do you have in life insurance? The cash value, ma'am.
Objection, leading. Objection, sidebar.
Overrule, you may answer the question. How much do you have in life insurance cash value?
$4,817.80.
Ma'am, you prepared this proposed property division, is that correct?
Yes.
And is it true and fair representation of the exhibits and all the things that you have talked about and want to talk about, ma'am?
Yes.
Is this a summary of your property division? We move to admit respondents number 5, Judge, with this.
Any objection?
Absolutely. Absolutely, Judge. It includes a multitude. In fact, the majority of it is
What's the objection?
Objection, relevance. Objection, facts not in evidence. Objection that it goes well beyond the scope of the appellate court's mandate. There is property in here which is not found within the final decree, which there has been no testimony elicited, valuation, which there has been no testimony elicited, and which is not contained within the decree.
Sustain.
Judge, everything on here is contained in the decree. That's why you have the exhibits on the side.
What the court is going to do is
move to admit, Judge. May I move to
I've already, Attorney Allen, if you would just be quiet for 1 second, you would hear my rulings. I'm not going to talk over you. The court will consider the portions that the Court of Appeals has mandated that the court considered. Everything else is not going to be relevant to the court's ruling. So you can admit it. The court will admit it, but the court is only entertaining those portions that was mandated.
Understood. Understood. Now, what about, ma'am, what about the debts of the marriage? On page 2 of respondents number 5, what do you want to make sure that he pays for, ma'am?
For all the credit. The City Visa, TJ Maxx, Wells Fargo Visa, Discover, funeral expense reimbursement, all the attorney fees.
Okay, and the prior attorney fees was how much?
Objection, Judge. Objection, Judge. Relevance. May I take the witness on voir dire?
Yes, you may.
Ma'am, you've got valuation for these debts on here. Is that correct?
Yes.
You provided no documents as of the 30-day deadline for this trial about these debts, did you?
There's no 30-day deadline.
Okay.
There
So
was no mediation.
so the pretrial order had a 30-day deadline to exchange documents. You provided no documents about these, correct?
No,
Okay, and these expenses had already been paid by you. You're
No.
asking that they be repaid, correct?
I had to pay it so I wouldn't go into bad debt.
So these balances are zero as of today, correct?
Yes.
Okay, pass witness. I'll renew objection to relevance.
Sustain. And the document is excluded.
I thought you just already,
Any document that was not timely produced pursuant to the court's
Oh.
trial order is excluded.
well, Judge, she did give him the divorce decree. The divorce decree was given and all of these amounts are in the divorce decree.
Counsel, you may ask your next question. You have 20 seconds left.
Are you asking them to, you asking this court to make sure that your attorney's fees are paid both to you and me that was previously ordered by this court?
Yes.
And let's talk about the newly found evidence, the McLaren. Now, the McLaren was part of the decree at the same time. We talked about
Objection, relevance, and leading.
Sustain. And Attorney Allen, you just ran out of time.
Okay. May
Attorney,
I ask for more time, Judge? There's no way possible that I can do a whole day trial in 20 minutes with all the objections and all the technical problems.
counsel, you are more than welcome to ask, and the court is going to deny that request. Attorney Davis, you
Judge, may I get in the title so you can verify who owns?
I'm just gonna mute you. I'm not gonna talk over you. Attorney Davis, any questions?
No, Your Honor.
Okay, Attorney Emerson, you have 40 seconds left. If you choose to give a closing, and Attorney Davis, you have plenty of time if you choose to give a closing.
Yes, just very briefly, Judge, we just ask that, sorry, is it time to
Yeah,
close? Thank you. We just ask that it be divided pursuant to the requested relief we've submitted. We're okay with either using Ms. Lay's numbers or Mr. Pham's numbers. Either way, the goal is to sell the house, and I understand those are exempt assets, but our goal is to satisfy the intervener in full. We also ask that the strict language of the decree regarding both the community estate and the Lamborghini as either the Lamborghini or not a component of the community estate based on its position in the decree be followed strictly, as that was the rule of the Court of Appeals. Thank you for your time today. I know you kind of squeezed us in. We really appreciate it.
You're welcome, and you just ran out of time. Attorney Davis?
Yes, Your Honor. I promise I will not use all 11 minutes. I agree with Mr. Emerson that the Court of Appeals mandate is limited to division. I disagree with him, obviously, regarding the treatment of what the Court of Appeals and what the decree says about the Lamborghini and what you found in your first run at this case. I believe the decree does say that the Lamborghini was purchased with community assets, which makes it a part of the community estate. What the Court of Appeals mandate did not contemplate was that a judgment creditor would intervene because that had not happened yet. We had not been instructed by the various courts and we didn't know about this divorce proceeding. I didn't get the underlying judgment. It came to me later. However, it is clear based on the family code, the judgment that was issued with findings of torts, that the non-exempt assets in the community estate are subject to execution to satisfy the judgment. And that's both Mr. Pham and Ms. Lee's, however the community estate was divided. For the intervener's part, I believe that includes the Lamborghini. The purpose of my examination today was to give you the VIN number of the Lamborghini. It is now in the record. The Lamborghini can be clearly identified. Mr. Pham testified that Miss Doe has only ever owned one Lamborghini and she owns one Lamborghini. So The question of which Lamborghini or what Lamborghini is resolved for the court today. If you look at page 52, section 3 of the original decree for the portions that have been affirmed, very curious about the McLaren, but that's not before the court today. The Ferrari is identified by VIN number. Each one of these individuals is entitled to $50,000 in exempt assets, and vehicles are included in that calculation under section 42 of the property code. You're also entitled to one vehicle. The Ferrari is worth more than $50,000, everyone agrees. So that cannot be the exempt vehicle. The Ferrari should be turned over to the interveners. The Lamborghini should be turned over to the interveners. The Mastercraft boat, which is in section 52, page 52, section 3, should be turned over to the interveners. These are non-exempt assets. You do not get an exempt boat. I don't care how much it's worth. The timeshare on page 42, W-3, should be turned over to be liquidated to the interveners. These are all non-exempt assets. The jet skis identified in H5 on page 40 of the decree should be turned over for liquidation. I believe Mr. Pham has designated the Lexus as his exempt asset or his exempt vehicle. I can't touch that. I can't touch retirement accounts. I'm not asking for that. Those are exempt. But these toys, these extra vehicles, I appreciate Mr. Emerson's position that Mr. Pham is going to satisfy the debt. In the year and a half that I've had this case, nothing could be further from the documentation. There's nothing to show Mr. Pham has any desire to satisfy this judgment. It's possible the only way that the Casaleses, who are in their 70s and still working because they lost everything, are going to get any satisfaction is through you and through the turnover of these vehicles. We have a motion for turnover on file. There's not a final judgment yet, but there is a vehicle before the court in which to do this via the turnover statute. We have a final judgment. Rule 31, I think, can apply. I don't really want to give these items to a constable because constables sell things and the return is 20 or 30%, and these are valuable assets. And I think it's in everyone's best interest that we maximize the value of these items. We can put it with a broker who sells exotic vehicles to maximize the recovery. I don't want to sell a Lamborghini for $50,000. That's not the goal here. It's not just to take stuff. The goal here is to maximize the recovery. I don't know, but however, I need everybody's agreement to do that. Otherwise, I've got to use the constable. But these assets, the non-exempt assets that I've identified, are likely the only way that Casaleses see any recovery at all. And so I'm going to ask that all of these non-exempt assets that I identified be, as part of the decree, delivered to the interveners. Thank you, Judge.
Thank you. Attorney Emerson, I got your message about the exhibits being sent. So the exhibits that the court has, petitioner, that the ones that were admitted, offered and admitted, petitioner's exhibit or a husband's exhibit, 1, 20, 18, 19, 23, 14, and 12.
I got 15 also, A and B.
50.
Well.
Yeah, they intervener offered it. I separated them as who offered it. Intervener offered husbands 15 and A and B. Is that correct?
Yes, Your Honor.
Okay, and for respondent, I have exhibit 3.
And Miss
And exhibit 5.
Exhibit 5 wasn't offered.
I offered it and you admitted it, Judge.
No, you offered it and you moved on. Exhibit 5 was not admitted. And exhibit 7 was sustained. The only exhibit was 3.
And that's the one I don't.
And that's the one we need.
So what did you say? I admitted it and you said what? On number 5?
No, you admitted it and you moved on. You
Oh, I didn't ask for admission.
correct. You started to do it, but then y'all started, you and Mr. Emerson, you started talking over him and then you moved on.
Judge, you said it'd be admitted, but the items in the debts would be excluded.
Okay, Respondents Exhibit 3 is what we have, and that's what we need. If you'd be so kindly to send that to my court reporter.
Okay, she doesn't have it. Well, let's see, what was number 3? So Judge, may I respond to the intervener?
No,
Oh,
no, testimony is closed. I was just giving everybody an opportunity.
never closed.
You ran out of time. So I was giving everybody an opportunity to let them know which exhibits that I had. So the court is going to take all the evidence that we have into consideration and see. Thank you all. That concludes the hearing.
Your Honor, we did not present a proposed decree because I'll be honest, that's not in my bailiwick, but we'll take a run at it if the court would like one.
Lynn?
A proposed decree?
Yes,
No.
Okay.
That's fine.
Okay.
I'll just do a memorandum ruling.
All right. Thank you, Judge.
Thank you all.
Thanks so
Thank you,
much.
Judge.
May we be excused?
Yes.